Sego, I'm Kanenhariyo. I'm Wakskare wage. Tyendinaga ninde wage no. I'm Kanenhariyo. I'm Bear Clan, and I live here in Tyendinaga, and I'm the war chief here. I just wanted to give an update about what's been happening with the court regarding the charges that a number of our men and myself got during the 2020 shutdown Canada solidarity action with the Mohawks and with Wet'suwet'en. We had closed the train for a number of days, and a few of us got charges. I think there was in total, at one point there was 28, but that number has been reduced. I'm not exactly sure how many people are currently have charges, because they keep dropping charges on people, but I think there's 14 of us left. Anyways, all of those of us who've been charged, we've had several court dates since August. There's been one in August and one in September, and then one a couple of days ago in October. And they're trying to set a trial date. And so back in August, the judge, he didn't want to set a trial date. He proposed that it had just been announced, just came out about the kids' unmarked graves, the 215 unmarked graves of children at the residential school in Kamloops. And so I think the lawyer gave me the impression that it was heavy on the judge's heart, and he had suggested or said that he would like to see that our court proceedings be handled in a different manner, that we couldn't just continue to use the same format, the same process to deal with these issues, because it's unfair and not working. And so he proposed that instead of setting a trial date, that we go before this other judge, and I believe his name was Judge Hunter, and make a decision as to whether or not we could reconcile with some sort, and he used the words reconciliation, to find an alternative solution that would be congruent with our treaty relationship with the Crown. So we have a peace treaty agreement that talks about how we sit down and address issues when there's been some sort of conflict. And so he was proposing that we handle it in that manner, and our legal team was supportive of that idea. And the Crown was apprehensive and said didn't know that whether they could make a decision, or they'd have to talk to somebody above them, whatever, blah, blah, blah. So anyway, there was a bunch of details to sort out how that would look, and who all the stakeholders would be, and that sort of thing. So there was a suggestion that the stakeholders would have to include the Minister of Indian Affairs, and I guess it's Indigenous Relations now, and maybe the elected band council on side with them, and as well as the traditional leadership and traditional government and the people as well. It became very apparent that there's a division in our nation and in our community, and so we've got two different distinct camps of political beliefs and philosophy operating within our lands. And so they suggested that maybe all of the stakeholders might have to be involved in the process. So it came to September, and the Crown had said that they didn't have enough authority or direction, and so they needed to speak with their superiors to come up with a date and a time that they could begin to flush out all the details about how this would go. So the judge in September, and I believe the judge's name was Judge Hunter, in Napanee, told them that they gave them another 30 days to have communication back and forth and get it sorted out, and so they could set a time to get this process started. And then they came back together a couple of days ago. I think it was 4 days ago now. And of course, it's all Zoom. They're all Zoom meetings, so it's not like not everybody's going to converge at the courthouse. So on that occasion, the Crown came. The judge was ready to hear what the plan was, and it turns out that the Crown didn't make any attempts to have any communication with our legal team, and came to the court ill prepared to set a time to begin the process to address the matter in accordance to our relationship, our treaty relationship, and within the principles or the guidelines, the ideas of reconciliation, as well as unprepared to move in that manner. That the Crown kind of gave the impression that they just wanted to go about it in the same manner that they have in the past, and they intended in the future to charge people, to get injunctions, charge people, drag them into the court, and then attempt to find them guilty or overwhelm them with the weight of court, and seek to have some sort of negotiated a plea deal or something like that. So totally not going along with or in support of what was the Minister of Indian Affairs was saying. Canada is just saying in the same day, saying, we have to give land back, and we have to recognize the traditional governance structure. And he was saying that about the Wet'suwet'en and the management of their territory, and that it's not Canada's. So at the same time that's happening, the Crown is saying, well, it's out of my pay grade. In fact, is what she said, out of my pay grade to make a decision to set a date to do a negotiated settlement. Now, a negotiated settlement is the same thing as a reconciliation. It's a solution that's outside of the regular court proceedings, and as a regular court proceeding to deal with it that way, and then come back to the court and say, this is the solution that we've come up with. Here's what we've agreed to, and the judge says, well, if both parties are in agreement, then I'll fine. That's fine. So the judge was suggesting that we create some sort of a pathway forward that would allow these kind of issues to be dealt with in that manner, and would create a new path, so that we're not continuing the same cycle of colonial abuse and using the colonial tools of the courts as a way to continue to harm Indigenous people. And so the judges were supportive of this. And it's the Crown who's been dragging her heels. But however, they were said, well, you need to go back to whoever you're above you. In fact, the Crown was asked, well, who do we contact? Who is it that's above you to make those decisions? And that Crown attorney wouldn't give a straight answer to either our lawyers or the judge. So there's a very interesting sort of scenario happening, but that's what's playing out. So there's another court date to go back in front of Judge Griffin, who's the judge that was originally seen back in August and refused to set a trial date because he wanted to see this alternative solution happen instead. And so it goes back before him on the 2nd of November, which is in a couple of days, to determine a trial date to move forward with a trial against those of us who've been charged. And for those of you who don't know, we were charged with I'm trying to remember now. There's 3 or 4 charges. One was mischief over 5,000, and that was associated with impeding the CN's access to their property, and then 2 was being inside a CN rail line. There's it's some sort of special CN law. There's some sort of line that they draw, and they say you're not allowed to be inside it, the work line, unless you're passing through it, but we're not allowed to be in it. I think that's probably what they do. They charge people if they're walking along the tracks, that sort of thing. This is the charge that they get. And then so there was those 2, and the third one was a breach of conditions of the breach of the injunction. Yeah, breach of the injunction. So those are the three charges that pretty much everybody that's being represented together Last of Us, that's what our charges were. There might have been a couple of people who got some other stuff. I'm not sure if those were dealt with or not. I had a charge of not showing up for fingerprinting. It's sort of funny. But yeah, so there's that one, but that's a little separate thing. So that's the crux of it. So we'll see what happens next, because we're going back in front of the judge who was refusing to set a trial date now to set a trial date. It's unclear as to what he will decide to do with that. We have got the evidence that's been put forward against charges against us. Primarily was a Facebook photos and video of people's personal accounts, the things that they posted as the police evidence and the Crown's evidence against the people. They didn't provide any of the police surveillance or any of the body cams or during the arrest time. The police had their own film crew there, and they didn't provide any of that evidence either. So it's very odd sort of charges, because they didn't provide really much of evidence against anybody. I mean, so that's sort of interesting in itself, as well as is a unique scenario, because during the time that the tracks were impeded, and I like to think about it as more of a political embargo. It was an economic and political embargo for Canada not be able to move any products to our territory in that manner, as a punishment or a reaction to their illegal invasion and occupation into Wet'suwet'en territory. And that was not something that was well presented or documented or said by mainstream media. They put it all towards in solidarity with the anti-pipeline movement, but in fact it was because they invaded and they went into Wet'suwet'en territory, which is not Canada. It's not Canada because Canada requires to have made a treaty agreement and acquired the land from them, their territory from them, with a treaty. That's what the Constitution says in the Royal Proclamation, the 1763 founding document of Canada. So the fact that they don't have that means that that's not Canada, that's Wet'suwet'en, and or Wet'suwet, or Yinta, I think is the word they use. That's the name of that country, and the RCMP are there illegally, and so we said, get out, and you're not going to use our lands as an economic opportunity while you do that to people that we have a political alliance with. So, anyways, this will be used as evidence against me, whatever, I don't care. So that's the update about that. So we go back November 2nd. If it moves in that direction for a trial, and then they'll have to go through all individuals and look at all the evidence, and they got to determine whether or not there's enough to have a trial, enough evidence for a trial. Then they got to set how many days aside. And then, of course, there's the fact that there's the whole question as to whether or not they, in fact, have the ability to charge us with the charges that they've charged us with, because they're claiming that it's their property. And while we were on the tracks, the elected band council submitted a land claim on the land that we were standing on, and it was accepted into the federal, the federal government accepted the land claim. So we're supposed to hear in November what the federal government's response will be about our lands and our land claim. So we're about to hear from Mark Miller, the Indigenous Relations Minister. I would assume we would hear from him as to their response regarding our land claim over a 5-mile wide, 12.5-mile long tract of land that includes Highway 2, the main line for CN Rail, and the 401 that passes by us. That it's all on our land, and we know that it's our land. We weren't process was never properly addressed in terms of alienation of those lands, and the people were against the alienating it. So that was back in 1823. So what's interesting is that I'm probably talking too long, but this is important because we're going to end up likely, if the Crown doesn't wish to find an alternative solution and go with what the judges are suggesting, that we forge a path in a positive way to address this kind of issues, and stop using the court as a tool for continued colonization. The Crown's going to find themselves in a situation where they're going to have to prove that CN Rail's property. And we already have all the research evidence and all the factual evidence that in fact it's not. And so the injunction was illegal because they made an injunction against us when it's our land. And so those charges can't stand. And then the claim that we impeded their access to their property can't stand because it's our property. And being inside the rail line, the work line, also falls into the fact that it's not their property. So they can't claim the work line on it because they don't have any agreement with us at all. And in fact, the only agreement that they have is that when we agreed to allow them to put a rail line through our territory, that was back in like 1912 or 1911, and it passed through our territory along the shoreline. They moved it in 1953. That old agreement said they could pass through, but we would have free use of the train forever. And so our people traveled on the train. In fact, we had 2 train stations in our territory, right on our land here at the Bay of Quinte, where we could get on and off the train, and people did travel to Six Nations and go to Walker, wherever they want, all over the country. And there was no clause in there that if the train was removed, that we would no longer have free access to use of the train. So they moved the train rail because they want to upgrade it. So they upgraded it and they ran it across our territory, which they had illegally seized, and that is where we were on the main line. And so we don't have an agreement with them over that. The elected band council, I believe, negotiated some sort of silly agreement in that one little spot on the land where they said that I think the students could get one free ride home once a year. That was the deal that they made. This is foolish because the elected band council is merely an extension of the federal government. They're literally the wardens of the prison, right? They're the workers that go around and sweep and mop up and whatever, and they just do what they're told. They don't have any right or have any authority or anything to negotiate anything, so they're foolishness. Anyways, so that's the updates. I would like to see that we find some sort of alternative that could be used to assist in other scenarios and as things progress and move forward throughout the country. It would be nice if there was a better way forward, right? They're just using this as a tool to try to harm people and to tie it all up and land claims and processes that are decades and decades long. This is nonsense. It could be a much smoother and respectful and this is about politics. It's not about crime. So that's the update, and that's where we are. And I'll give another update when we get a little further along. Thank you. Have a good night.
Let's just quickly record an introduction.